So a very, very significant judgment from the Allahabad High Court on 12th January. The High Court has held that the provisions of the Special Marriage Act, which require a 30-day public notice period for any impending marriage under the Act, which allow members of the public to file objections based on this public notice to the marriage, they've held that these provisions cannot be mandatory and can only be applied if the couple actually agrees to this, because otherwise it would be a violation of the right to privacy and the right to freedom of choice. Now, it's a very significant judgment in terms, especially because we've seen all the controversies recently regarding the UP interfaith anti-conversion ordinance, which is basically targeting interfaith marriages, which is meant to tackle the bogey of love jihad. So this is a very, very important judgment, and it reaffirms a lot of the rights which are important for couples looking to get married at this point of time. Now, what exactly was the court having to look at here? Well, the Special Marriage Act is meant to facilitate interfaith and intercaste marriages. At the same time, because it's an old legislation and because it was enacted at a time when compromises were having to be made within, between conservative and progressive elements of the Congress party, what happened was that this law actually continues to include these provisions which say that you have to have a notice period, you have to have objections from the public coming in, and this has led to a great deal of harassment of interfaith couples. And this interference and this, the pressure which gets put on them because of this whole process, which allows their families, which allows right-wing goons to get to know and object to their weddings, this has led many couples to actually look instead for the route of having to convert, for one party to convert to the religion of the other and get married for the sake of convenience through that. Now, this was in fact the one of the things which was raised by a couple before the Allahabad High Court, because they were there. It was a Hindu man and a Muslim girl. The Muslim girl had actually ended up converting to Hinduism to get married, and still her family was objecting, and there was a lot of problems which had happened, and they had to finally have a habeas corpus petition to get her free. But they told the court that one of the reasons why they had to go down this whole route was because of the problems with the Special Marriage Act. And so the court decided, let's look into this whole situation, and because it's a question of people's life and personal liberty. Now, when they did that, they found that, look, you've got provisions which are making it difficult for people to get married. It's creating an unnecessary public spectacle out of this, because marriage is a personal matter of choice. And they looked at the way the Supreme Court has developed its jurisprudence over the years on the right to privacy in the landmark Puttaswamy judgment from 2017. They looked at the Shaktivani, the honor killings judgment from the Supreme Court. They looked at the Hadia case. All these cases where the Supreme Court has evolved their jurisprudence on this and said very clearly that the right to marry, the right to choose a partner is something which is purely a private internal choice for two consenting adults. Nobody else gets to make a decision on that, whether the family, society, the state, the courts, nobody. And so because of that, they held that this provision, as it stands, by making it mandatory and not allowing an element of choice, is a violation of the right to privacy and the right to choice, which is an intrinsic part of your right to personal liberty. Now, what they also found was that this provision is discriminatory, because if you're getting married under the Hindu Marriage Act or Muslim customs or any other religion's personal laws, you actually don't have to do any of this. You don't have to have a notice period. There's no question of objections from the public. It's only for those who are going through the Special Marriage Act. And so they found this was actually discriminatory as well. Now, on this basis, the court has now held that this provision is unconstitutional and it can't be left as it stands. Now, does this mean, of course, that it's going to apply across the whole country immediately? Not exactly, because number one, this is passed by a state level high court, so it directly applies throughout all of UP. Other states, people can use its reasoning to make an argument, but it doesn't directly automatically apply. If we're looking at the other big question, which is, does this stop the scourge of, the harassment of interfaith couples and the kind of problems created, in fact, under the new UP anti-conversion ordinance, which, as we all know, is meant to tackle the whole bogey in the conspiracy theory of love jihad. Now, that has led to a lot of harassment of interfaith couples as well. So will this help there? Unfortunately, it won't exactly, because in terms of the new ordinance itself, it won't directly help because these are two entirely separate laws. So even though the court's reasoning to a large extent applies to a lot of what's going on with the harassment of interfaith couples there, it doesn't directly apply. At the same time, indirectly it does, because one of the reasons why you actually have couples having to have one side convert to the other, whether it's a Hindu girl converting to Islam or a Muslim girl converting to Hinduism, or even the guy converting to a different religion. All of this happens because a lot of the time, because they're trying to avoid the harassment created by the Special Marriage Act, which would have been there otherwise, the way in which they could have got their interfaith marriage done. So now that that's out of the way, there is a possibility that some of that harassment will come down. At the same time, there is a risk that this will not necessarily lead to a massive change on the ground, because one of the reasons why there is so much harassment, whether it's by goons, whether it's by families, is because the marriage officers who are supposed to be helping these couples get married themselves leak this information out to informants, whether it's from families, from villages, from village panchayats, or whether it's from organizations like the Bajrang Dal itself. So we may not necessarily see immediate changes on the ground because of this, but it is a very, very important step, a very important move towards recognizing and affirming the right to privacy and the autonomy of individuals and consenting adults to choose their life partner. So something which hopefully will become a useful precedent, whether it's in other high courts where this issue is at play or in the Supreme Court itself.